Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
Next case the court's going to take up will be State of North Dakota versus Jesse Lee Dill, file 47-2024 CR 242. Ms. Depute is present in court. Mr. Dill appears in person by reliable electronic means from the Stutsman County Correctional Center. Good afternoon, sir. Were you present in court when your rights were read to you earlier?
Yes, sir, Your Honor.
You understand your rights?
Yes, sir, Your Honor, I do.
One of the most important rights you have is the right to be represented by counsel at every critical stage of the proceedings. Bond is a critical stage of the proceedings. You previously appeared and waived your right to counsel. We're here for a subsequent hearing, a bail review. Bail is currently set at $1,000 cash or corporate surety. That was set on 6/14/2024 by Judge Schachman.
Yes,
It has additional conditions. It's been more than 48 hours since Judge Schachman set your bail. What is your request for the court, sir?
I put in a new application for an indigent for counsel. Also, I wrote a letter for review for indigent counsel too. Also, is there any way possible I can get a PR bond? I have no means whatsoever to get $1,000 or even 10% of $1,000. He presented me as a flight risk, and I'm not. I just recently had another PR bond on another case in another county that I showed up for court like I was supposed to. I'm trying to do the right things. I'm not going nowhere. This is going to be my home. If I have to take probation in the end, prison sentence, whatever may come from all this, I'll accept it like a man. I'll accept my punishment. Right now, I need to get back out there so I can get some work. So I can I can't do it from in here. And a month sitting in here, that's a lot of wages. That's a lot of wages I could get out there. You know, and I did have lined up for some work. I just can't do it from inside here. I really need a PR bond, sir, if possible.
All right, so we're going to talk first about your application for public defense services. You did submit an application on 6/17. I reviewed that application. You indicated that you worked 40 hours a week at $13 an hour and didn't do the math.
I filled out the wrong.
So, hey, stop talking. It's my turn to talk. Okay.
Yes, sir.
So what that works out to be, 40 hours times $13 an hour is $520 a week or $2,080 a month. The indigent defense guidelines are about $1,500 per month for a single individual. So your income exceeds the guidelines by about $500 a month. I said that you may reapply if your financial circumstances change, if you're unable to obtain or retain private defense counsel. You must submit at least 5 retainer quotes and an affidavit concerning your efforts to obtain counsel for the court to consider overriding the guidelines. So I denied your request for counsel, and I did so a day and a half ago. It was after hours on the 17th that I signed that order saying you just make too much money. You're still in custody, but at this point, the court's going to find you ineligible financially for public defender. If things change, you certainly can reapply, and I just explained to you how you can do that. With respect to a PR bond, Ms. Depute, what's your position on reducing bail from $1,000 cash surety to PR as requested?
The state maintains that the amount of bail is correct. We had actually asked for a higher amount. Judge Schachman entered bail in the amount of $1,000. The defendant has 2 outstanding warrants out of Georgia. To my knowledge, he has pretty limited connections to the community. He indicated, I believe at the bail hearing, that he has a residence. However, the charges and the information I have indicate otherwise. They suggest that the defendant was potentially squatting in the property that he had trespassed upon. His criminal history, though, is pretty substantial. It does include some non-recent violent offenses. The warrant indicated violent tendencies for the 2 Georgia warrants. I think that the amount is reflective of the risk of the defendant not appearing and the inherent public safety risk posed by the defendant.
Ms. Depute, are the warrants out of Georgia extraditable?
It did not look to me that they were, but I didn't confirm with Georgia whether or not they intended to extradite.
And what are the warrants for?
They are for there's one that indicates limited extradition. I will pick up within 200 miles for to indicate whether it's a revocation or a new count. A second one is for armed robbery. We'll pick it within Georgia. And those are the 2 that I'm aware of.
What are the dates of the warrants?
The date of the warrant. I don't see that it indicates the dates that the warrants were issued on the interstate record.
Thank you. Mr. Dill, I saw you raise your hand. Go ahead.
I did submit a handwritten letter to you for a review and another application for indigent counsel because I did fill out the other one wrongly. I had a job at the Hampton. I thought it was asking me the question of what was my previous job beforehand. I do not have a job, sir. That's why I resubmitted the application for indigent counsel. I'm not trying to represent myself. I have no money to do so. I just turned it in yesterday with Sergeant Evil. She was supposed to turn it in for me. It is supposed to be in the process, the workings now. Sir, I need a PR bond so I can get out there and earn some money, sir. I wasn't squatting like that. The guy they think I was is a guy named Kyle. I'm trying to do the right thing here. I just don't want to sit in here for somebody else's doings. The warrants from Georgia, they're non-extraditable. They're in-state pickup only. They were issued 2019. One of them for violation of probation. Sir, I'm not on no probation right now in this state. I have been doing good. I got caught up in the wrong thing. They think I'm the guy named Kyle, and I'm not that guy. He's the one that's squatting, not me. I ain't got no way to prove it. Promise you. I just don't know what to do here, and I just don't want to sit in here for somebody else's doings. And it's like, everybody knows I've been doing good in this town since I've been back. I've been back a month, and I ain't done nothing wrong. I had a job, and they were treating me wrongly, so I quit that job. And that was what was on the application. And I was in the means of looking for another job, sir.
All right, so here's what I'm going to do. In terms of the request for public defense services, I don't have that application, sir. The most recent application that I have is from 6/17/2024, and that one was denied for the reasons that I said before.
Yes,
Whenever I receive the other one or the one that you submitted, the court will review it and determine whether or not you qualify for public defense services. But I'm not going to do that right now because I don't have the application in front of me. With respect to your request to amend bail, the North Dakota State Constitution has a presumption that all defendants are bailable upon sufficient sureties. There's U.S. Supreme Court case law concerning what sufficient sureties are, indicating that for an indigent defendant, even a modicum of bail might result in preventative detention. Our state rule on bail, Rule 46A, has a presumption of release upon one's personal recognizance and or unsecured appearance bond, unless the court has reason to rebut the presumption. And then the court can look at things like criminal history and things like flight risk and dangerousness to the community. Here, the court has sufficient information to have some concerns that the defendant will not appear in court, as demonstrated by the outstanding Georgia warrants. Certainly a Georgia court had a tough time getting you back to court. That's enough for the court to rebut the presumption of release upon one's personal recognizance or release on unsecured appearance bond. I'm not saying that establishes that you are a flight risk, but it is something the court is going to consider. It's enough to overcome the presumption of release upon one's own recognizance. The court is going to reduce, sir, I'm talking.
Yes, sir.
The court is going to reduce the bail that is required to establish release, at least monetarily, but not in as much as the defendant wishes. So bail is currently set at $1,000 cash or corporate surety. Bail is going to be reduced to $500 cash or corporate surety in the amount of $1,000. So I'm basically dividing the bail that was put in place before in half. You still do need to either post $500 cash or find a bail bondsman that would be willing to post a surety bond in the amount of $1,000. All other conditions of release remain in full force and effect. Bail is reviewable if you remain in custody for 48 hours following today's hearing.
I have a question, sir.
What is your question?
Is there any way we can get a 10% on that? Because I don't know no one around here. I have no money out there, sir. I have nothing to my name. There's no way I could do anything from in here. I have one friend out there in the world, and she's a very old lady, and she don't have that type of money. But I know she could maybe get $100 for me if it was on a 10% of something.
Sir, I've already made my ruling, so you can review it if you remain in custody, but that's my ruling for today.
Yes, sir.
With that, we're adjourned
Yes,
in
Your
this
Honor.
matter. All right. Court's going to recall State of North Dakota versus Rhiannon Darlene Huff-Stetler, file 47-2024 CR 222. Ms. Depute appears on behalf of the state. Ms. Huff-Stetler appears personally by reliable electronic means from the Stutzman County Correctional Center. We're here for a bond review. Bail was set in this case
I need to go out.
originally on 6/4/2024 at $5,000, 10% plus the 24/7 patch and other conditions. Bond was posted. Since then, there have been 2 affidavits of probable cause filed for 24/7 violations, both frankly relating to the same incident. The first dated 6/17/2024, alleging that the patch was off, and the second on 6/18/2024, indicating the defendant appeared for patch changeout, and the patch was then retaped onto Ms. Huff-Stetler's arm. Ma'am, first of all, were you present in court when your rights were read to you earlier?
I was.
You understand your rights?
Yes, sir.
Do you have any questions about your rights?
No, sir.
One of those rights is the right to be represented by counsel. You can always hire your own lawyer. You can apply for a public defender, and if you financially qualify for one, the court would appoint you a public defender, or you can choose to represent yourself. How would you like to move forward?
I will represent myself for now, sir.
Has anyone threatened you, forced you, or coerced you, or in any way made any promises to you in order to get you to waive your right to counsel?
No, sir.
You understand that you can change your mind at any time and either hire a lawyer or apply for a public defender as long as your case is still pending.
Yes, Your Honor.
All right, so you heard me say bond was recently set, you were released, you were put on the 24/7 patch. And really what it appears as though we're here for is you were picked up, and it would have been yesterday, on 2 affidavits of probable cause, record index 8 and record index 10, concerning your patch, quote unquote, falling off and then being retaped onto your arm. Is that right?
Yes, sir.
So your bail reverted back to $5,000 cash, and you're asking the court to amend bail in some way, shape, or form. Is that right?
I don't understand how this whole thing works. So I guess so.
So right now your bail is set at $5,000 cash because that was the alternative to 5,010% plus the 24/7 patch. There's an allegation that you did not comply with the 24/7 patch program.
Okay.
And so that's why you're back in jail. You were arrested as a result of the 24/7 violation that was alleged. You're appearing now in court. What are you asking me to do?
Pardon me. I am asking you to give me another chance at the 24/7 program. I am 110% dedicated to that. I am willing to do anything to keep myself in line and to prove that I am serious about, staying on this path of sobriety. What happened to my patch was it had maybe like a third of the way it came off. And that was the night before I had called Jess Hartman, I believe her name is. And so I did tape it back down because I didn't want it to peel off any more further. She said to come in, don't come in, it's up to you. And I had taken that the wrong way also. And so she said that she put a warrant out for me, and I turned myself in, sir. As soon as she told me that I did have the warrant, so I could get it taken care of. And here I am.
All right. Ms. Depute, I'm going to treat Ms. Huffstetler's request as to essentially put her back on bail as previously ordered. It sounds like she's been there for a day and turned herself in. What are your thoughts?
I think that request is appropriate in this case. From the pictures, it does look like the patch remained mostly on. It does have many of the hallmarks of a tamper, but since this is the first violation, given and Ms. Huffstetler's own actions to return herself in, I think that allowing her to be released and have a second chance in the drug patch without requiring additional bail is appropriate.
All right, what the court's going to do here is the defendant has been released on bail, 5,010%, earning the alternative $5,000 cash, 5,010% plus a 24/7 drug patch. There's been an allegation of a 24/7 sobriety program drug patch violation. The court finds that that violation has occurred. The court, as a sanction for that violation, sentences the defendant to 1 day in jail at the Stutzman County Correctional Center, credit for 1 day served. The defendant may be released from the jail. The bail order entered on June 4, 2024 remains in place. The affidavits of 24/7 violation, record index 8 and record index 10 address the same violation and are hereby quashed. I've signed that order so the jail can process you out. Ma'am, make sure you're following the conditions of bail as they've been set. Future violations might result in additional consequences. Do you understand that?
I understand, sir.
All right. So with that, we're adjourned in this matter. Thank you.
Thank you.